Clappercorruption Part 2. The purpose of this video is to expose deliberate abuse of power and violation of EEO law by the EEOC's Office of Federal Operations Director Carlton Hadden. Mr. Hadden's deliberate abuse of power and violation of EEO law was to protect James Clapper and the National Geospatial Intelligence Agency, or NGA, as commonly known, from being found guilty of breach of settlement, discrimination, retaliation, and to protect 3 EEOC administrative judges at the Baltimore field office from being found guilty of violating my civil rights, to protect the NGA from being found guilty of discrimination and retaliation. The EEOC's Office of Federal Operations is not here to protect the civil rights of Americans, but to shield federal agencies from being charged with violating the civil rights of black people. Don't be fooled. Although the OFO Director Carlton Hadden is a black man and an HBCU graduate, he has consistently violated my civil rights for white federal directors, managers, EEO judges, and agency attorneys, as you will see below. Even when the agency is blatantly wrong, he rules in their favor. The focus of this YouTube video is on Carlton Hadden's deliberate abuse of power and violation of EEO law to protect the NGA from being found guilty of breaching the 1 June 2012 settlement agreement that has me without my $125,000 a year federal job and security clearance, unable to provide for my family, and unable to pay for my 2 children to attend college, and other things too numerous to mention. For every federal employee who has ever received a questionable decision from the EEOC's Office of Federal Operations, or OFO as it is commonly called, please listen carefully to what I have to say. My name is KIRK WEBSTER Sr. As I stated, the purpose of this video is to expose the EEOC's Office of Federal Operations Director Carlton Hadden's abuse of authority and unlawful decision of no breach, which occurred in a 19 July 2013 OFO decision letter, even after the National Geospatial Intelligence Agency admitted to breaching my 1 June 2012 settlement agreement with them. In a 4-page letter dated 30 April 2013 from the NGA's own EEO director, Ms. PATSY COLEMAN, that was mailed to me, the appellant, KIRK WEBSTER Sr., OFO's Robert Barnhart, Director of OFO's Compliance and Resolution Division, and the NGA's Associate General Counsel, Ms. Barbara Rickert. The OFO docket number of the breach settlement is 0120 13 1177. I will show you this 4-page letter from the NGA admitting to breach right now. This is page 1. This is page 2. This is page 3. This is page 4. The use of a magnifying glass will better aid you in being able to read those 4 pages that I have shown you. The EEOC's OFO violated my civil rights even after the agency admitted to wrongdoing. Because of the irrefutable evidence that shows the OFO blatantly violated my civil rights, I am demanding justice. Toward the end of my previous video, Clappercorruption, I stated that I had 2 appeals pending at the EEOC's Office of Federal Operations, or OFO. This appeal concerns that the agency deliberately did not inform me of my discontinued service retirement benefits. On 3 February 2016, the Office of Federal Operations of the EEOC affirmed the agency's dismissal of my complaint, stating, based on the evidence in the record, we find that the 1 June 2012 settlement agreement entered into between the parties bars the complainant's complaint. Therefore, we find that the agency properly dismissed the instant formal complaint. Moreover, We are in agreement with the agency's appellate assertions that the instant formal complaint is merely an attempt by the complainant to relitigate issues or claims that were previously raised before the Commission. End quote. The agency's final decision dismissing complainant's formal complaint for the reasons stated herein is affirmed. The OFO Director, Carlton Hadden, states, and I repeat, based on evidence in the record, we find that the June 1st, 2012 settlement agreement entered into between the parties bars the complainant complaint. But what Mr. Carlton Hadden didn't say is that the NGA openly admitted in writing to breaching the 1 June 2012 settlement agreement in a 4-page letter dated 30 April 2013, signed by the NGA's EEO Director, Ms. PATSY Coleman, entitled Breach of Settlement Agreement Decision, noted as Exhibit B. After the NGA's EEO Director, Ms. PATSY Coleman, mailed a letter to me, the appellant, KIRK Webster Sr., the OFO's Mr. Robert Barnhart, the OFO's Director of Compliance and Resolution Division, who is also a subordinate of OFO Director Mr. Carlton Hadden, and the NGA's Associate General Counsel Barbara Ritter, admitting to breaching the 1 June 2012 settlement agreement. It was later the OFO who issued a decision 3 months later on 19 July 2013 unlawfully stating the settlement was not breached. The agency's 30 April 2013 letter states, the correspondence from your legal representative specifically alleges that shortly after signing the settlement agreement, you received a letter on 27 July 2012 from the Defense Finance and Accounting Service noticing you of an overpayment to you in the form of the agency's payment of federal employees' health benefit premium from September 24, 2011 to June 30, 2012. The DFAS letter was a demand for payment of a total debt of $7,449.18. Your legal representative's letter further states that you believe the signing of the settlement agreement had resolved all claims between yourself and the NGA. To support your allegation, Mr. Doremus Esquire cites paragraph 2C of the settlement agreement, which reads in part, the submission of this agreement to the EEOC and MSPB will constitute a request for closure and dismissal with prejudice of all litigation between the parties, including but not limited to the activity identified in Section 2B of this agreement. He further writes that the agreement states that the scope of the agreement resolved all claims that arose from or are related to the complainant's employment at NGA. Mr. Doremus Esquire notes that the debt to DFAS was resolved by the settlement agreement and suggests that an attempt to collect the debt is a material breach of the agreement. This is found on the third paragraph of page 1. Page 2, third paragraph reads, after careful review and consideration of the settlement agreement and documents you submitted to support your claim, the agency finds that an unintentional misinterpretation of the agreement exists, or at the very least a mistake occurred during the construction of the contract. This decision is based on the fact that both you and the agency's legal representative, Jack Rickert, agree that the settlement agreement resolved claims that arose from your employment with NGA. Therefore, in response to the OFO's Mr. Robert Barnhart's 3 February 2016 decision, affirming the agency's decision to dismiss my complaint due to the terms of the 1 June 2012 settlement agreement, I stated the following upon reconsideration. The below response is based on the fact that the OFO's appellate decision involved a clearly erroneous interpretation of material fact or law. The OFO's 3 February 2016 decision, noted as Exhibit A, is another act of deceit and retaliation that is related to the OFO's 19 July 2013 unlawful decision of no breach in favor of the National Geospatial Intelligence Agency. Based on evidence in the record, the National Geospatial Intelligence Agency, or NGA's, EEO Director PATSY Coleman states the following in an agency decision letter dated 30 April 2013 entitled breach of settlement agreement decision, noted as Exhibit B. The agency finds that an unintentional misinterpretation of the agreement exists, or at the very least a mistake occurred during the construction of the contract. The decision is based on the fact that both you and the agency's legal representative agree that the settlement agreement resolved claims that arose from your employment when NGA. Page 2, third paragraph of Ms. Patsy Coleman's letter. Although NGA's EEO Director Patsy A. Coleman forwarded a copy to the Equal Employment Opportunity Office of Federal Operations Compliance and Control Division Director, Mr. Robert J. Barnhart, as noted on the last page, page 3. The OFO deliberately ignored the agency's 30 April 2013 decision letter, in which the National Geospatial Intelligence Agency admitted to breaching the 1 June 2012 settlement. The OFO's Carlton Hadden unlawfully forced a decision of no breach, because a decision of no breach prevented the OFO from rendering decisions on pending OFO appeals regarding 3 corrupt administrative judges at the Baltimore field office. The pending OFO appeals questioned the honesty and integrity of EEOC administrative judges Charles Shubo, Samuel Titleman, and Mary Elizabeth Palmer of the Baltimore field office, who allowed NGA's Associate General Counsel Jack W. Rickert, a responsible management official in several of my pending OFO appeals and EEO complaints, to discriminate and retaliate against me with impunity. The OFO Director Carlton Hadden wanted to have the final word on my career. OFO Director Carlton Hadden went as far as stating in his 19 July 2013 decision that the agency did not issue a final decision, which was an outright lie. The NGA's 30 April 2013 decision was the NGA's final decision on the breach. The agency's Associate General Counsel Jack Rickert, Edward Kendall, Ura Cherry, and the OFO's Director, Mr. Carlton Hadden, have all stated that I am barred from taking several actions that I have initiated, such as EEO appeals and complaints and MSPB appeals, due to the 1 June 2012 settlement agreement that the NGA EEO Director Patsy Coleman openly admitted in writing was breached in her 30 April 2013 breach of settlement agreement decision, that the OFO did not have the authority by law to change to a decision of no breach, just to render an unfavorable decision against the appellant that was to their liking and benefit. The OFO's recent 3 February 2016 decision certificate of mailing shows that a copy was provided this time to NGA's EEO Director, Ms. Patsy Coleman, but in their 19 July 2013 no breach decision, the OFO stated the agency did not issue a final decision. Then the OFO submitted a copy of their decision to former NGA Acting EEO Director, Mr. John Sikowski, who, according to NGA's Associate General Counsel, Jack Rickert, has not been with the NGA in over 10 years. The OFO deliberately did this because they knew NGA's EEO Director, Ms. Patsy Coleman, had issued the decision on 30 April 2013, affirming that the 1 June 2012 settlement agreement had been breached. I have requested of the EEOC Chair, Ms. Jenny Yang, and President Obama that an Office of Special Counsel investigation be conducted on OFO Directors Carlton Hadden, Robert Barnhart, and NGA's Associate General Counsel Jack Rickert, because they all have violated my civil rights, as seen in the information that I have come forward with. My civil rights have been deliberately violated by the same OFO officials whose positions at the EEOC require them to protect my civil rights. I believe the OFO Directors Carlton Hadden and Robert J. Barnhart have aided the NGA in violating my civil rights for years and allowed NGA's Associate General Counsel Jack W. Rickert and NGA employees to discriminate against me with impunity. The fact that EEOC's OFO Director Carlton Hadden has aided the NGA and taken away my $125,000 a year annual salary, my thrift savings plan investment, my ability to provide for my wife and children, the ability to pay for my children's college education, and almost forced me to lose my home of 20 plus years, and prevented me from finding professional employment related to my 23 years of federal service, is like unto a modern-day lynching. These OFO directors have aided the NGA in destroying my family's livelihood and must themselves be removed from federal service, so they want be able to injure anyone else in this way. The actions that resulted from Mr. Carlton Hadden and Robert Barnhart ignoring Patsy Coleman's 30 April 2013 breach of settlement agreement decision admission has been brought to the attention of President Obama and EEOC Chair Jenny Yang. I would like Congress to be informed by way of a congressional hearing after the OSC investigation is completed. I am demanding immediate relief and that back pay according to the Back Pay Act is awarded me. That I am also awarded default judgment on all pending OFO appeals and NGA EEO complaints prior and subsequent to Ms. Patsy Coleman's 30 April 2013 letter admitting to breach. I am also requesting pecuniary and non-pecuniary damages, and that the OFO directors Carlton Hadden, Robert Barnhart, and NJA's Associate General Counsel Jack W. Rickert are removed from federal service. I do believe NGA and the OFO have colluded to deliberately take action to prevent me from getting my security clearance and professional employment related to my 23 years of experience. The actions of these OFO and NGA officials were deliberately taken to adversely affect my family's quality of life in retaliation for pending OFO appeals and NGA EEO complaints. As the Bible says, truly, spiritual wickedness is in high places. Copies of my reconsideration letter was provided to Mr. Robert Barnhart via email at robert.barnhart@eeoc.gov, Carlton Hadden via email at carlton.hadden@eeoc.gov, EEOC Chair Jenny Yang via email at jenny.yang@eeoc.gov, President Barack Obama via email at barack.obama@whitehouse.gov, Patsy Coleman via email at patsy.a.coleman@nga.mil, Agency Representative Ura Cherry via email at ura.cherry@nga.mil. That's EURA.CHERRY@nga.mil. Thank you very much for listening.